Hello everyone, welcome to Administrative Law Lectures. I'm Marjina Sultana, an Assistant Professor from Interpersonal Law College, Greater Noida. In the previous video, we have discussed delegated legislation. In today's video, we are going to look at control of delegated legislation. As we discussed in the previous video on delegated legislation, we understood that to delegate means to pass power, to pass authority to another. Delegation of power means the power passed on by higher authority to the lower authority to make laws. So, delegated legislation means the powers given by the legislature to the executive or administration to enact certain laws. Under delegated legislation, there are mainly three kinds of control mechanism. The first one is parliamentary or legislative control, second, executive or administrative control, and the third one is judicial control. So, the question arises, why do we need to control delegated legislation? We know that delegated legislation, there is a large number of delegated legislation. More delegated legislation is passed than that of the primary legislation with less scrutiny. So, and also the delegated legislation is not looked at as carefully as the bills in a parliament would be. So it is important to exercise control over the delegated legislation to make sure that the powers delegated to the lower subordinate authority are duly exercised and that there is no abuse of authority that the executive is provided with. To check the abuse of authority, there is the need of control of delegated legislation. First of all, let's understand control of delegated legislation by the parliament. Both the delegation of power, the power to supervise, and controlling power is with the legislature. Because under parliamentary democracy, it is a function of the legislature to legislate. It is not only the right but also the duty of the legislature to look upon its agent how they are working. So, parliamentary control over delegated legislation is an inherent constitutional function because the executive is responsible to the legislature according to clause 3 of Article 75 of the Constitution. The article provides clause 3 of the Article 75 of the Constitution provides the Council of Ministers shall be collectively responsible to the House of People. This implies that Parliament should oversee the work of the government and hold it responsible for its action and omissions. So there are a variety of ways the Parliament control the way delegated legislation is made. Executive is responsible to the Parliament at two stages. In the initial stage and in the second stage. In the second stage, it is direct and indirect control. Direct and indirect stage. So let's first understand how Parliament control delegated legislation in the initial stage. We know that, as we discussed earlier, every piece of delegated legislation requires a parent act. Parent act, that is the primary legislation passed by the legislature. which provides the framework, guidelines for the subordinate authority for the delegated legislation. So this delegated legislation is to be made according to the Parent Act, according to the legislature. Okay, so that Parent Act itself provides the limitations on the power of the subordinate authority to legislate, to make delegated legislation. So in the initial stage, the power, how much power is to be given, how much power is to be delegated is decided. It is also decided whether this delegation of power is valid or not in the initial stage. In the second stage, there is two parts, direct control and indirect control. In the direct control, laying is important. Direct control is done by laying the rules as per the requirement, and in the indirect control, this is done through scrutiny committees. So first, coming to the direct control, laying is an essential aspect of the direct control. It is laid down as per the requirement, which means that after making the rule, it should be placed before the parliament. It includes, again, it includes three important parts as per the degree of control needs to be exercised. The three part is, the first one, simple laying, second is negative laying, and the third is affirmative laying. In the simple laying, the rules have to be just laid down because it is laid down without any intention for further discussion or direction. It is just meant to inform that the rule is made. And in the second stage, that is negative laying, it is subject to the negative resolution procedure. Means these, under this stage, under this part, negative laying, it will automatically become law if not rejected by the parliament within 40 days, or we can say within a reasonable time period. If the resolution is passed to annul the law, if the resolution is not passed, then it will automatically become law. Okay, so unless it is rejected, it will become law. And in the third laying, that third kind of laying, that is affirmative laying, it is subject to the affirmative resolution procedure. That is, it depends on the approval of the parliament. So the simple laying is a very weak control. Okay, it does not include any kind of discussion or debates, etc. And the negative laying, this is more common. Okay, and the affirmative is more stricter control, strict kind of control. Here it depends on the approval of the parliament. And in the, okay, these are the three important part of laying. It depends on the degree of control. The first one is the weakest one. A simple one is the very weak kind of control, and the next is negative laying, and the most strict control is the affirmative laying. This laying has two main tests. First one is test of mandatory, and the second is test of directory. Where the laying demand is the condition pattern to guide the rule into impact, then in such a case, laying need is mandatory. It means that where the provision is mentioned in the Parent Act that the rules should be drafted in a particular format, then it becomes a mandatory to follow that format. And in the test of directory is that where the laying need is next to enforce the rule into operation, then it will be a directory in nature. This laying is have two tests, mandatory and a directory. It will be mandatory. Laying need is mandatory if there is a provision mentioned in the act that it should follow a particular format. And in the directory, there is no such provision. Okay, so let's understand another kind of control, that is indirect control. It is exercised, indirect control is exercised by the parliament and its committees. This committee is also known as Committee on Subordinate Legislation. So the main work of this committee is to examine whether the rules are according to the general object of the act, that is, whether the rule, that is delegated legislation, is according to the object of the Parent Act. Okay, and the second one is whether it bars the jurisdiction of the court in direct or indirect ways. So this act, delegated legislation, cannot bar the power of judicial review, because it is a judicial review is a basic structure of the constitution. So what the committee will check is the basic thing, that is whether it is according to the Parent Act, whether it is according to the it violates the constitution, whether it bars the jurisdiction of the court, whether it has retrospective effect or not. We know that generally there is presumption that the law is not a to a retrospective one. It should not be having a retrospective effect but a prospective one. Okay, so if the committee will check whether it is having a retrospective effect or not, because it is meant it should not be made retrospective, and whether it destroy the principle of natural justice or whether it safeguard the principle of natural justice, whether the expenditure involved is from the consolidated fund of India. So these are the ways Parliament control over the delegated legislation. To sum up, there is two stages: initial stage and the second stage. In the initial stage, the power is decided, how much power is to be given, whether the delegation of power is valid or not. And in the second stage, control is done in two ways: directly and indirectly. In the direct control, the subordinate authority has to lay down, has to place the rules before the parliament, and it involves simple laying, negative laying, and the affirmative laying, which are which depends on the degree of control needs to be exercised. And in the indirect control, it is done by the committees to examine whether the delegated legislation is according to the Parent Act, whether it is according to the principle of natural justice, whether it bars the jurisdiction of the court, the power of judicial review, whether it is having retrospective effect or not. This video ends here, and we will be discussing executive or procedural control and the judicial control of delegated legislation in the next video. Thank you.